Welcome back and many thanks for staying with us. The judiciary is stuck with 26 billion Uganda shillings on its account, well, in unclaimed fees and also these security deposits over the last 10 years. The judiciary's chief registrar, Sarah Langasu, attributed this to strict requirements and lack of awareness on this process, that many Ugandans would rather abandon the money and then get into the bureaucracy required to actually receive this money. Today I'm having Simon Musangala from Musangala Advocates and also Jameson Karamani, the spokesperson for the judiciary. They are here to help us make sense of this issue. If the chief registrar Sarah Langasu is saying the issue is awareness, then it is imperative that we have the spokesperson of the judiciary coming in to shed more light, and a lawyer also to explain why people are not going for this money. Very good morning, gentlemen. Thank you for joining us.
Thank you for calling us.
Jameson, let me start with you. Why are individuals not clamoring for their bail refunds?
Thank you very much for inviting us to shed light on this issue. Yesterday, the chief registrar came out to explain this issue, because we have been with this issue for some time. It has been raised as an audit query whenever we go to Parliament and reflect these monies as part of our accounts. So this money has accumulated for over 10 years. It's not yesterday's money. It has been close to 10 years when it has been deposited.
So from the walk-to-work protests and everything that we've been seeing, these individuals who are getting bail up to now? Up to now.
So first of all, we have to understand how this money comes into this account. When someone is charged with an offense and appears in court, most times they apply for bail. Now, when they apply for bail, in some cases, the judicial officer, that is the judge or a magistrate, will order that the person should deposit some money as security. It's security before that person is released on bail. That money is deposited as security, meaning that at the end of the case, if the person complies with the terms that were given in the bail, that person is supposed to have that money back.
You're talking about court appearances and so forth, up to the very end. So it doesn't matter if you are innocent at the end of the day or guilty, you have to get the refund as long as you adhere to the bail conditions.
Exactly. What matters is that they told you to report on such and such a day.
And you are there.
And you are there. You kept doing it until the end of your case, whether you are acquitted or convicted. As long as you abide by the terms, you deserve to be refunded the money. Now, at the end of the case, when it ends, we have not been having, in some cases, our judicial officers have not been clear to these people. When the case ends, they say you are acquitted, and that ends there. They don't explain to you that the money you deposited, you should come back and collect it. So that is one of the reasons.
And it's not intentional?
It's not intentional, but they didn't look at it as imperative to explain to the person whose case has ended, either in a conviction or an acquittal, to tell him that since you abide by the terms that were given in the bail, you deserve your money. So you claim your money, it will be refunded. So that was one of the reasons. And that one has been collected because the principal judge came out and gave practice directions at all the judicial officers that at the end of the case, the judicial officer should pronounce himself on the issue of the bail that had been deposited. So that one, we hope that going forward, it will be one of the ways of collecting that. The other reason why some people have not been coming back, of course, is ignorance, which is being collected by that explanation. They didn't know that at the end of the case, even when I'm convicted, I deserve a refund of my money. So they just leave it and go away and keep quiet, and it keeps with us. The other explanation is about the documents. When someone is released on bail, there are some documents he fills, what we call the bond, and he's given a copy which he keeps using when he comes back to court. And the judicial officer keeps, we call it renewal, keeps signing on it to show you appeared today, you are supposed to appear on the next day which they have given you until the end. So that bond is supposed to be there to help him also to prove at the end of the day that he was attending court. Some people misplace that at the end of the case. The other one is about when you deposit the money, it is deposited in the bank. At the moment, there is no money which is collected at any court. All monies that come into court are paid in the bank. You just come with a deposit slip.
And that's what Sarah Langer meant when she said stringent requirements.
Exactly.
Money coming through the bank. She also touted the possibility of using mobile money later on.
Yes. So when someone has paid the money in the bank, he has a bank slip, which he keeps and comes with it to the court and say, I have deposited the money. Then our staff, who is the cashier, is supposed to issue him a general receipt in addition to the bank slip.
So in the event where you lose those documents, you don't get paid.
It becomes difficult
to prove that
not that you don't get paid at all, but it becomes a little bit difficult because all these claims have to go through the auditors for purposes of checking, because if we don't, people will abuse the process and the money gets into wrong hands. So when you don't have them, it may not be as easy as the one who has presented those documents.
Indeed.
So some people misplace those documents, and now they have to look for the alternative. The alternative is, if you have lost those documents, now we ask you to swear an affidavit, because we want to also commit you. In case you are lying, at a future date you can be held responsible. So we ask them to swear an affidavit, which is now used to claim the money.
I see.
So now that some of those processes are the ones which could have caused that.
I see.
But now that's why we are coming out. We are explaining to the public
to create awareness right now about this.
Even if you have lost the documents, please approach the court and explain. They will help you out and see the alternative.
Of course, that is a game changer. If you've lost that slip from the bank, please move over to the judiciary. You'll be able to be helped in that regard. I also do have Simon Musangala from Musangala Advocates. Now, from your experience as an advocate, why are individuals not clamoring to go get their money?
Thank you very much, Romeo, for inviting me.
Yes, Simon.
I'm glad to share a podium with His Worship, the spokesperson of the judiciary. Personally, I think, to begin with, the bureaucracy. There's a lot of laborious bureaucracy.
I hear you loud and clear, but break it down.
As far as getting these funds is concerned.
Break it down.
Secondly, first of all, the judiciary is working on the presumption or assumption that every bail applicant has a phone, and secondly, has an account. This money is not given to you in cash. It has to go through your personal account, not even the advocate's account.
I hear you.
At the time of applying for bail, advocates are very instrumental in ensuring that clients get bail. They are actually the ones that give guidance to the applicants to ensure that they go through some of this process.
Indeed.
However, at the time of claiming for these funds, the lawyers or advocates seem to have been eliminated in this equation, because you cannot even claim to have instructions to receive bail refund on behalf of a client. It has to go directly to the client's account. I want to give you an example. If you are to get money, you have to make an application to the court that gave you bail. The court receives the application. All right. The application goes to the clerk. A requisition will be made, and it will be sent to the secretary to the treasury. The secretary of the treasury sits in Kampala. Now you are talking about somebody in a Kapiripirit who has paid 150,000 to be bailed out. The expense of following up that money
could be more than.
Could even more than that. So I believe that could be one of the reasons why litigants or other fellows who are supposed to be entitled to their money just give up. Secondly, I'll give you an example. I have a case in one of the courts, and the DPP happened to have withdrawn those cases. It's now 2 months. We wrote on behalf of the client to receive the funds. The question is, the judiciary does not have guidelines, proper guidelines on how people can get money. There is no time frame. So the fact that somebody goes to court for more than 5 times to look for this money and it's not forthcoming, the person sees no reason as why he should continue wasting more time, more money to chase money which is not coming, which is not forthcoming.
Continue.
Secondly, I am glad the judiciary has now woken up from the wits of slumber.
Indeed.
To clear the air and create awareness among the population. Your worship has told the nation that this man has accumulated for the last
10 years.
10 years. What has been done in the last 10 years by the judiciary to ensure that the people are aware of their obligations?
Jameson Karamani, what has been done in the last 10 years to ensure that these individuals receive this money? Because it's not yesterday, like you mentioned.
Maybe before he comes
and he also mentioned that for 2 months he's been chasing his bail money for his client. It was never received.
And maybe
Simon, finish.
Before he comes in, should I be right that because there's a proposal by government to take money that is in all dormant accounts that have been money that has been on accounts unused and so forth, that the judiciary is now coming up to say, okay, maybe government can easily take this money and the judiciary will be into trouble? Should that be the reason?
Not really, because
I'm not saying that's the reason.
I could be devil's advocate on this one, because Sarah Langasu came out and said, no, they will be calling on to members of the public to actually receive this money in the forthcoming days, weeks, or months. You simply have to go to the judiciary and you actually claim this money. Mobile money is also being touted as another avenue through which money could be sent to those claimants or litigants. Why is it taking so long for individuals to receive their bail money? What is the timeline for the refund, Jameson Karamani? For the last 10 years or so, why are we having this conversation now?
Now, what we have to look at is that we are coming out to see how we can correct whatever may have been wrong. We have to look at the process that is taken, and of course the process was taken there, was put there, like I said, to have checks and balances, because we might rush to claim for the money, and again it lands in the wrong hands. So the process is, when a case has ended, we call it an application, but it's a simple one, because you just write, even in a handwritten letter, and say, I had a case in court under this number, I had deposited so much, I'm requesting it to be paid back to me. Now, the stringent condition of paying it in the bank and not paying cash, and also paying it on the mobile money of the person who deposited it, was put there to check the wrongdoers, because the money would be landing in the wrong hands and end up not going to the right people. Council has talked about eliminating the lawyers. Yes, it was also another stringent measure, because some lawyers would claim that money, pick it, it doesn't reach the person who has they say, you are owing me balance of my fees, and they take it. So the person still now comes up complaining, I deposited the money, I did not receive. So we said, let it go directly to the account of the person who deposited it.
Because some claimants deposit money through the advocates.
Exactly.
So meaning it's the person who deposited the money to actually claim for it. Meaning the lawyer can come receive the money, minus me, the litigant, even ever knowing.
Exactly. We are even saying, even the relatives can't come up and claim it. Some relatives, when the person is in prison, they mobilize. Even some people offer the money and say, let me give this 1 million for him to get out. So when it comes to the time of claiming it, the person who brought the money thinks that the money should be going directly to him. So we say no. The person we know in court is their choice. So it should be that person to receive the money. So the process, after you have put in your application, which is in the form of a simple letter, indicating the bank account, attaching the receipt, the court will also put the order which shows that they have ordered the refund of the money. Now, it is now the duty of court, not the claimant. Once you put it there, the court takes it on. They will send it to, because this money, when you pay it, it goes on, there is a central account. It doesn't remain in the local court down there.
I see.
It goes on the central account. Now, when that application it is sent to the secretary, stroke permanent secretary for the judiciary, because that is the person who is controlling all the funds in the institution. It will go through the auditors. They have to look at it, because this is money which is in the hands of court. When they see that everything is okay, now they will advise the permanent secretary to pay. That is the time now when the money is moving from that account to the account of the claimant. So the person who is claiming does not have to come to Kampala that he's going to follow up that money. He's only supposed to check with the court. What are we doing now? What we are doing is, one, we are sensitizing the public to know that this money which you have deposited, it is your money. When the case ends and you have followed what you are told, that money will come back to you.
Now, the viewer is asking him or herself, after 10 years, why are you coming out now with this awareness drive? Why not in 2015, 2012, if you will? Why now?
Yes, we may have come now, but we have been looking at the situation of, like, the money has been there, and we are saying, why are people not coming to pick it?
I see.
So we are coming out to now.
So it was judiciary as you asking yourselves the question?
Exactly.
Okay.
Money, some people claim it, but it has not been all going away. So some money remain. In a year, if you had received a deposit of, like, let's say 1 billion, you find 900 has been claimed, people have come for it, but that 100 million is there. So you keep wondering why. Then we came up with a solution and said, let's now find out what is the problem. We found that some people were not coming because of the reasons we have given. Now, we have also put up guidelines, which in the future, when they are operationalized, will be managing that bail process right from the time the person gets bail up to the time when the person is refunded.
How long does it take for one to be refunded?
Now, at the moment, we are saying it should be 7 days.
He has taken 2 months.
He has taken 2 months.
Without receiving bail money for his client.
Some exceptions come in, and that's why we must find out for his case why. Because people have received that money in the time I am describing. So some exceptions, why is his taking long? I will pick interest. I'm going to pick interest and find out. Because sometimes people give wrong accounts. When it reaches here in the center and they are wiring money to the account, it bounces back. Then we have to go back to the process and ask the person to now put in the right accounts. So it's not that it is generally taking 2 months. There are exceptions which have taken that time, but many people are receiving that money in time. The other one which we are studying is at the time when the person is granted bail, the person fills in a form indicating at the end of the case where his money should go. Now, when he has filled that and he has put all the requirements, when the case ends like this and he has abided by the process, the court orders that that money should be paid on that account. So we just hope that if that is operationalized, if you can get into that,
I see,
it will be quicker, because there will not even be requirements of the person claiming it, because it will be automatic. The case has ended, you followed the procedures you are given, you have your account which you've submitted, the money is reversed back to
Simon Musangla, do you feel that this is a deliberate move to make it harder for these litigants to actually access this money with these stringent requirements? Is it deliberate, in your opinion?
I think it's not deliberate. The issue is that the judiciary had inadvertently or through its challenges failed to come out to make a proper pronouncement on this. And now that it has come up to clear the air on how this is supposed to be done, I think we are heading for better days. One thing you need to know is that yes, it was not only on the judiciary's own evolution that this issue has come up. Definitely there has been so many complaints in the principal judge's office in respect to this issue. And that's partly one of the reasons that propelled this issue to become an issue of concern to the judiciary. As you are aware, the new PJ, I don't think he has been there for more than 3 years. Is a relatively new person in the job. And I will be honest that they have done, so far, they have done good work. I'll give you an example. We had instances where the stringent measures courts put are not only on bail refunds. You could go and apply for bail for a client.
Wait. That is another conversation. First, finish the issue of bail reforms. I'll take you there. Don't worry. Don't worry,
Thank
Simon.
you.
I'll take you there.
Thank you very much. Now, let me get back.
Yes.
On the issue of bail, one thing, the courts have records. This person has been appearing in the court every day. The general receipt that is issued to the bail applicant,
Yes, Simon.
a copy of the same remains on court record.
I see.
Because a court cannot grant you bail, a magistrate cannot sign your bail form without certifying that all those documents are on file.
In a nutshell, it should be judiciary looking out for these people.
If the judiciary is up to its game, and there are people who have reasonably lost out on their documents, the judiciary has every copy of the documents of the bail applicants on their record. In fact, nowadays they even have, you cannot get bail without attaching either your national ID or passport. So if I come and tell you, okay, I've been in court, I've been appearing in court, my case has been dismissed, or I have been convicted, and I have all evidence on court record, why should the judiciary push me to go and look for the document that might have got burnt in a house somewhere in Budaka?
Indeed.
You get it? Why can't they use these documents to serve somebody who has been in the court for over 5 years to get his refund? So I think the judiciary should explore this for ease, because you see the judiciary is it is the maiden hands of justice. So if you make it difficult for people to get their
The money will stay there.
the money will be there doing nothing. And now this brings me to another issue. Out of the 26 billions, how much was forfeited out of this money so that it goes on the consolidated fund?
Indeed.
For purposes of government using it? Have they done an audit?
How many litigants died?
How many of
and did
them
not
died?
receive this
And
money?
if they died, what advice do?
And remember, the money cannot go to the family members.
It
because
cannot
the
go to
person
family
who died
members.
was the depositor.
Was the depositor? So that means somebody has to look for what we call letters of administration, the
I hear
estate,
you.
and so forth.
Indeed.
So the whole intention, at the end of the day, it becomes a problem. For
So
somebody.
Simon, here we are talking about the individual who was even lucky to receive bail. There's that individual who is never lucky when they even apply for bail. Let's talk about how difficult it is to actually even get bail in this country. It's not for the poor. It's for the rich. That's what I'm hearing. How true or false is that statement?
Thank you very much.
Meaning,
bail-
if I'm a chicken thief, I could end up in jail if I do not have bail. If I kill someone, I could get out on bail if I have the money. So is bail for the rich?
I really don't want to say that bail is for the rich. Bail is a constitutional right for everyone. Every person who has committed or suspected to have committed a crime and is brought to court has a right to apply for bail.
But if court sets the bail at 50 million and I do not have it, am I going to end up wallowing in jail?
The right to apply for bail is a right. The right to be given bail is a discretion of the judicial officer.
Indeed.
And that's where now the judiciousness of the judiciary or the judicial officials has to come in. You don't grant bail by attaching stringent terms, because at this time a person is still innocent until proven guilty or until he pleads. So in my heart of hearts, I believe if a person, I have had a scenario in court. What you're talking about is right, but this is an individual case by case basis, where a person was allegedly charged in court for obtaining money by false pretenses, over 50 million, and he was ordered to pay 20 million shillings in cash bail. It is there.
Jameson Karamani, please respond
So
to this
judicial
and a lot
officers
more.
are given discretion, but this discretion should be exercised judiciously. But some of them abuse it. That should not be an issue or a policy of the judiciary.
All right, let's give
But the
Jameson
key-
Karamani the last few minutes before we wrap up this conversation. Jameson Karamani, the president, is proposing the tightening of the discretion of the judicial officers to actually award bail and the police officers to award bond, and comes at a time when you are expediting awareness on people to go and receive bail refunds.
Thank you very much, Remu.
The timing.
The debate has been going on about bail. Bail is derived from the Constitution because of the presumption of innocence. So a person who is charged with an offense has a right to apply for bail, and then the court has the discretion to grant that person bail. That is the Constitution. Now, when it comes to the discretion is exercised by looking at a different case, case by case. The judicial officer looks at what offense is the person charged with. After studying that is when he will now either grant bail or not grant bail. If he grants bail, what conditions should be put there? They are not standard. They are all determined according to the case. Now, for the case which the council has cited of 50 million, and then you are asked to deposit 20 million, like he has said, those are individual people, and those situations can be checked, because if it is a grade one who has done that, you can write to the chief magistrate. The chief magistrate will review whatever condition the person has set if they are unfair. If it is a chief magistrate, the High Court can review that. So either to grant bail, we are waiting for whatever comes up. The debate where it will take us. For us, we are here.
Is this money lying idle on your account, or are you using it somewhere in judiciary? Before I let you go.
This money, we can't touch it, because once it is a security, it means a person can come back to pick it anytime.
If I died and I can't come back,
if
what do you do?
died, your estate is entitled to receive that money, because it is part of the estate. So what we have actually done lastly now is we are asking for records from the courts. All the courts are going to submit records on bail, and with the names of people who applied for bail, and we shall study them, and we shall try to reach up to those people to see how they can receive this money.
All right, Jameson Karamani and Simon Musangala from Musangala Advocates, thank you very much for having made the time to speak to us on this very sensitive issue. And of course, it comes at a time when the Attorney General is proposing changes to Article 23, Section B, 6B of the Constitution, and also Article 23, Section 4B of the Constitution to tighten the discretion of judicial officers to award bail and so forth. Let's take a breather, return shortly with more information. Keep it here.